customer, this new demand, would consume only about 1/10 of the available water supplies in this portion of the district. And if you look at water actually delivered district-wide, their projected annual use would be about 150 acre-feet per year, and over the last 5 years we're averaging about 41,000 acre-feet per year in deliveries. So that's about 1/3 of 1% of our overall demand. As was pointed out by Director Wheeldon at the last workshop, that 150 acre-feet a year is less than is consumed by the Cameron Park Country Club. The future wastewater service, for the reasons that I indicated, that is speculative in our view and not reasonably foreseeable from the signing of the MOU. The MOU calls for actions that would allow future wastewater service and put the parties in a position where they might be able to obtain it or provide it, but it does not require it, and it doesn't impose any commitments upon either party. As I indicated, there are many unknowns that separated that potential scenario from where we stand today. I want to cover some additional information and public concerns that arose since May 12th. Since May 12th, I obtained a transcript of the July 1988 audio recording of the LAFCO meeting at which the annexation was approved. I've attached that to the staff report, and I won't go into it in detail, but suffice it to say that I believe it fully supports the factual analysis that I presented on April 28th with regard to what the intent and effect of those LAFCO restrictions was. Also obtained a copy of the actual recording itself, which is a little more complete than the transcript, and to the extent that it's more complete, it is more favorable to the factual analysis that I've already provided you. Public comment also raised the issue of whether this project was consistent with El Dorado County's general plan. I took a look at that, and I put information in your staff report about that. The general plan designates this land, as it does many federally owned lands in the county, as AP, which stands for Approved Plan. And under general plan policies, when that is the case, the map of the approved plan is automatically adopted as El Dorado County's general plan map, and the plan itself is adopted as the plan for that property. So anything that has an AP designation in the El Dorado County general plan is automatically consistent with that plan. One other letter that was received just yesterday from the City of South Lake Tahoe raises two questions. One is, well, let me go get the letter because I've forgotten what one of the questions was. And by the way, copies of this letter were provided to all the board members and are available to the public at the back of the room. Yes, the first question was a factual one over whether the Bureau of Indian Affairs ever formally approved the 1998 or 1988 annexation of lands to the district. There is no evidence, as far as I know, and I think it would have surfaced by now, one way or the other on that issue. But my legal analysis of that issue is that there is an evidentiary presumption in California that official duties are regularly performed, and therefore the burden of proof would be on someone who was asserting that approval did not occur in a court of law. So we are entitled to presume that annexation, especially after 20 years' time has passed, was valid and all necessary steps were taken. The second question was also asked at the last workshop, and that is, how can you separate the LAFCO restrictions and their validity from the validity of the annexation action itself? And the answer there is that the federal doctrine of preemption preempts state regulation only to the extent necessary to avoid a conflict between the state regulation and the federal purpose. And the act of annexing the rancheria in order to make public water available to it doesn't create any conflict with the federal interests at stake. On the other hand, the restrictions, taking back essentially most of what was granted by the annexation, do conflict with the principles, the federal interest in tribal sovereignty and the specific interest in allowing specific land uses, i.e. gambling under the Indian Gaming Regulatory Act, on the rancheria. So the doctrine of preemption is a surgical one that can carve out conflicting areas while leaving other state enactments that don't conflict with the federal interest in place. And in my opinion, that is how that principle operates under these facts.
Eric?
In layman's terms then, what you're saying is if there are invalid or unenforceable or illegal parts of that contract, it doesn't negate the whole contract. The rest of the contract is still enforced, or the agreement is still enforced, so it doesn't cancel that out. That's basically what you're saying.
That's right. You under federal preemption, you have the privileged position of not having to take the bidder with the sweet. You get to keep the sweet and reject the bidder. Before getting to the options, I just want to sort of take a moment of personal privilege here to say that I think there's been some misunderstanding among the public in what my role is in this process, but I have no misunderstanding about that, and I'm confident the board has no misunderstanding. My job is to advise you on the law, and I've done that. I've told you how the law applies in this case, in my opinion. My job has also been to represent you in negotiations with the tribe, and I've done that, and now I've provided a document for your consideration. But the decision about whether to sign that document or not is a policy decision for the board to make. I've made a recommendation because that is also my job as staff, but I have no illusions about my role in this, and once I present the options to you, my job is done. I have been a player in this saga for about 10 years now, and I have advocated various positions at various times in my duty representing my client. But my own personal opinions are irrelevant, and I am not advocating any position to you as a matter of policy. That is your decision to make. So I wanted to clarify that before presenting the options to you. Option 1 is to adopt the resolution that would approve the settlement agreement, memorandum of understanding between the Shingle Springs Band and EID, and making findings associated with that. Option 2 would be to take other action as directed by the board, and option 3 is to take no action. The recommendation of your general counsel and your general manager is option 1, and I'd be happy to try to answer any questions.
At this time, I'd like to open it to the board for questions, but if there's anybody in the audience that wishes to speak to the issue, I only have 2 people signed up. If anybody would like to speak, Deanne, would you raise your hand, and she'll provide a card for anybody that would like to speak. With that, open it to the board. Mr. Frazier.
2 points, Tom. We have seen and heard of actions that have been taken and not taken by LAFCO. Has the district been provided with any official position by LAFCO with respect to our moving ahead on this issue?
We had a meeting with representatives of LAFCO at which they did present a position. I believe that was authorized by the entire LAFCO board.
Well, I noticed the executive officer of LAFCO is here, so perhaps he could clarify exactly what LAFCO's position is at this point.
I think that would be much better than me trying to speak for them.
Okay, the other question I have, and maybe our water flow expert out here might be better qualified. The people in my area have brought to my attention a number of times the question of adequate flows that have, in their opinion, been inadequate over the years. In your presentation, you have made the statement that the flows will improve, if anything, over what they have been. Could we have a statement, perhaps from Brian or somebody that could